creature of the Constitution and a creature of the sovereignty of 55 million people. It is not above the Constitution. The orders that have been issued and are being implemented are to be implemented within a legal framework created by Parliament. The Basic Education Act has not been amended or repealed on the requirement of what should be submitted. There is no reason the petitioners can submit what is lawful. My Lord, what the petitioners' counsels are telling this court is to incite the court that there is anybody disrespecting the authority of the court or challenging the decision already made. What the respondents are putting to this court is the difficulties of implementing that court order. What the respondents are pushing is to bring to the attention of the court the consequences of implementation. Are courts having eyes and ears outside the courtroom? Yes. Among the matters that were not brought before this court is the question of the Kenya National Examination Council. And the interface with the court order that now is in place. There is a blind push for implementation. My Lord, the question about children who are in school starts with the United Nations Convention for the Rights of the Children. It cascades down to the African Charter on the rights and welfare of the children. It moves to Article 53 of the Constitution of the Republic of Kenya about the best interest of these children. Creates two statutory statutes, that is the Children Act and the Basic Education Act. none of the children are before you to cry to you to understand the pain. Of a child who is either going to have her career destroyed by the same institution mandated to protect the vulnerables. This is a weighty decision, my Lord. The petitioners are pushing as if the heavens are coming down today. They are blind to their own children by virtue that they are parents. All of us, those children at that school are our children by virtue that we are above 18 years and we have children elsewhere. And it will go in history that the judiciary never listened to the cry of children. Who are saying, allow the exams and the assessments to proceed. The consequences of deregistration is monumental to the lives of vulnerable children, more so slum children. But those children are not like mine or like anybody's children who is here, who can go to another school, who can go to India, who can go to America. Those children have nobody called a father, have nobody called a mother. It is the court that is their protector. As this matter is a private commercial interest, the court should look deeper and see the children beyond the commercial interests. You will have time to make notes. Nobody will stop. My Lord, what I'm asking and I'm urging this court, the framers of this country emphasized that we are fighting poverty. Now, ujinga, education is very critical. If we do not see the value of education for those thousands of children, and we see the commercial angle, we'll have destroyed our generation. A generation that looks at Omari and say, you are my voice. We'll have destroyed young advocates, and the president will have nobody being admitted as an advocate. The future is our children. The future is not on structures. My Lord, weigh the consequences of your pen. It's a mighty pen. The respondent there has told you, if you tell him, register now, he'll register because of the consequences of the mighty pen of the court. What will be the unforeseen consequences? My Lord, nobody is disobeying the court orders. This was a judgment by another judge. You are only enforcing and giving life to that judgment. My Lord, is time of essence in this matter? That this thing must be done tomorrow? In the reverse, time is of essence for those thousands of children. None of the protagonists is bringing others as a question before you. The Ministry of Education is in everybody's bedroom because children are manufactured everywhere, every bedroom in the country. It is only ministry that everybody has a child, therefore the Ministry of Education is in that place. It is a critical issue. My Lord, see that picture. I wasn't there when the hearing was there. I could have brought to the attention of the court to see the global picture about those children. The Attorney General has properly put it. Did the court summon the Director of Children's Services as statutory office?
I will cut you short. I'm not sitting on appeal.
No, it is about the implementation.
For the decision of His Lordship.
Okay, my Lord.
I am not reviewing it. Mine is to implement as is.
As it is.
Yes.
I'm only asking for time of implementation. What the respondents are saying, allow them. Nobody's challenging the decision of the learned judge. Enlarge the time. If the orders will be sent for registration, there will be an order to the examination council to deal with these issues I'm raising. For there to be a seamless transition for these children. Minus the examination council. These are commercial entities, my Lord. Did the children create it? Should they be killed because these people did that?
No, I'm asking you. I'm asking you.
I am moving that there is the court finding that is not challengeable. Did the court factor the children? The court looked at the question of ownership. Should the children be killed because of the question of ownership? Or should the children get away? And that is why the other time I said, unless we bring the Kenya National Examination Council specific orders like those ones, that when the certificates will be issued for these children who have registered the exam, they will be issued based on a court order. But if we leave these children in suspense, the skunk creators have been punished by the court. Must the children die? That was the philosophy during the Pharaoh's time, that once the Pharaoh dies, people must be locked in to escort the Pharaoh to heaven. Do we take our children that road? And that has been brought to you, my Lord. It has been brought to you. It is on the court record.